Good morning, Sint Maarten. What's up? What's cooking? December 4th, 2023, episode number 107. Today, though, I'm going to dedicate this discussion to the verdict of my court case last week, Thursday, and where I go from here and what it really means right now. Let me start off with this. The courts have spoken. I know if some buts about that. They gave a verdict, and we have filed our appeals at cassation. This is going to take some time, naturally, because the process is we file our filings in Sint Maarten, go to Curaçao. From Curaçao, they send it to Holland. We get lawyers in Holland ready to write an advice. They will write an advice to us based on the case file. If this is something advisable to take to the Supreme Court, if they say yes, they will then await the date that we get from the Supreme Court to present our filings. Once that is done, then we will await to hear the verdict of the Supreme Court. This is basically how that will work. Now, the reason I'm telling you some of these things is before this really plays out, elections have taken place, and when I win, I will be able to take a seat in Parliament. Now, naturally, you must understand this. I was deeply hurt when I heard the verdict last week, Thursday. And, I felt bad for two reasons. One, my wife was implicated in a case that she had nothing to do with, and they thought maybe by implicating her and trying to punish her, they would break me. Let me make it clear to everybody. You can't break bunks. You can hurt me, yes. And I've been hurt now because I truly had faith in justice. But I'm gone. I'm gone now altogether. And that has woken up a warrior inside of me now, because it was clear that a goal had to be reached. Now, I want to stay on script as much as I can today, because I need the message that I'm going to share with you all today to be clear. I'm going to be reading emails between the judge of first instance and my lawyers. I'm going to be reading some pleading notes from the defense counsel to show you that what was written in the verdict of last week, Thursday, are blatant lies. Not just inaccuracies, no, lies. I am bold enough to state it on this podcast. So they can look at it in Curaçao, they can look at it in Holland. Because now, yes, I ain't bending no knee and I ain't rolling over playing dead no more. Tis what they want. I know what I'm fighting. I know who I'm fighting. But you know what? It takes one to start. And eventually, the rest will come. Because today's Soban Camper. But for who it's going to be tomorrow? Because many people have been taken out to send messages. But that's not really justice, right? When I entered that courtroom last week, Thursday, I was convinced I was walking out a free man. Convinced. Because the job my lawyers did was par excellence. When I looked at the face of the Solicitor General, he was unsure of what was to come. Normally they know, but he was very unsure. When the video screen went on and I saw one of the three judges, because one has now moved back to the Netherlands, I started to get a weary feeling with the smirk on his face. But you know what? You never prejudge. You wait for judgment. As I sat and listened to the head judge read out a verdict that seemed to have been written by an intern who didn't read the case file, I started shaking my head in disbelief, as I knew that the evidence was there to clear me, or at least cast very serious doubt on the evidence of the prosecutor's office. I can live with a decision when that decision is well put together and supported by arguments that explain why the defense arguments were not accepted. A decision that applies the law in a proper way. But not this verdict of 9 pages with about 3 explanations on the 100+ pages of defense of my lawyer, Miss Peggy Ann Brandon, on why I couldn't be found guilty and the various breaches of the fair trial procedure, the equality of arms, the abuse of power, and I can go on and on. When you review the verdict, a few things became evident very fast. The verdict seemed to just focus on trying to correct and validate procedural violations of the previous courts, so the courts of first instance, protecting a fellow judge, all ignoring the evidence brought in by me to counter the decision in first instance. With, like what we say in Dutch, kort om de bocht, quickly penned down decision as if they remembered last minute that the verdict had to be put on paper. The decision in first instance was upheld. So haphazard that one of the counts brought against me was not even mentioned, but never handled. So in the verdict, one of the charges against me wasn't even discussed or put on paper. Snips and bits were used to say I had power to give the contract according to the testimony of a former Minister Myers, whom, by the way, was sent packing for all the wrongdoings in the Vineyard Heights land. Mind you, the same Minister Myers signed the damn advice and sent it to the governor. But he tells them, oh, I was pushing for Roberto and Sons. Yes, I was. You know why? Because the other choice was 1.5 million guilders more. And my boss, the SG, Brown, he wrote the memo stating that the advice should be given as written. But I had the power. Only me. The governor's control of the advice and the approval of the advice by the Council of Governors didn't mean anything, as only I had the power to grant the contract. That's what the judges saw in a 6,000+ page case file with documents leading from the day we started the tender to the day we granted the tender. By the then Prime Minister, Marcel Gums, the then Minister of Romy, Claret Connor, the then Minister of Romy, Angel Myers, and I can go on and on. But I had the power. One man had the power to decide everything, including what the governor must sign. That's what the judges said. I had the power. Clearly, they didn't read it well enough or refused to understand the way government procedures and approvals work. To see the fact what Meyer stated wasn't possible and the truth didn't look so. But they took it so because that was convenient. Another fascinating piece in the verdict was none of the witnesses ever stated that they gave me money, because none did. In all the written statements of Leroy Lapierre and Roberto Babadou Flanders, none of the two ever, let me use that word again, ever stated they gave me money. I have decided to call names now so that we don't believe who said what. No, I'm telling you what it is. You can go and ask them. Ask them if they gave me money. Ask them if they ever testified that they gave me money in my hand. Ask both of them. Then you will know the story. Because I'm tired of the manipulation and the lying by the courts. The judge of instruction clearly confirmed that the statements on paper by the court in first instance were incorrect. Let me read it again. Another fascinating piece in the verdict was that none of the witnesses ever stated that they in person paid a bribe. And that the judge of instruction in appeals here clearly confirmed that the statements on paper by the court of first instance were incorrect. Not correct, incorrect. They did this on the oath by the judge in appeal. Their lawyers had reported this also, and the judge first agreed to postpone the trial to correct the statements, and then proceeded with the case without correcting the statements. I am going to read you just now email correspondence between the judge in first case, Stefan van Lieshout, and my lawyer, Hyler Broom. Because there are no secrets. You're all using things to try to nail me to a cross when you know that you're wrong. But because you wear that black toga and sit on the bench, you believe you're above the law. You're not. No, you are. Nor me. Their lawyers reported. So I'm now talking about the lawyers of Lapin and Roberto. Reported this to the judge and told the judge it's not correct. The judge agreed in a written email to my lawyer that he is willing to postpone the trial to December. So instead of November, to December. Because what was put on paper and given to us Friday evening, 6:15, to go to trial Monday morning, 9 o'clock, was incorrect. So the judge said, okay, if everybody can agree, we will postpone to the 21st to the 23rd of December 2021 to go to trial so we can fix the documents. This is Friday afternoon, people. We didn't have the documents at that point in time yet. But we were having problems. The appeal court claims that those statements that were used in first instance, uncorrected, let me say that again, uncorrected, based on what we sent to the judges. Because in my PV, they say I had about 20 or 30 things that were incorrect. One thing was changed, and the PV was good. But I'll explain you why just now. The appeals court, like I said, claimed that those statements were correct because it is what the court recorder heard. Mind you, what the court recorder heard. Imagine the statement had parts in it that were never brought up in courts. Yet the statement the court recorder wrote was the statement of a witness, even after the witness said, I never said those things. And I'm now talking about Lapin and Flanders. I'm talking about them. Me and my wife also said, we did not say those things. But they heard them. You remember some time ago there, Terence Riss wrote about the zombies in the courthouse? Start to think. Both of these statements at the judge of instruction and appeal clearly stated they never gave me money. Go figure. Because in the statements that they want to use, that they said was written 2 months after the statements were made. And you will hear it in the emails just now, that those were good, even though everybody objected to them. Both lawyers did, and all defendants did. The appellate court accepted the word of the court recorder who wrote down not what was said, but what she felt she heard. That's the problem. Now, listen to this. When I walked into the hearings in first instance, I asked if I could tape the hearings, and the judge of first instance got a wizzy fitty. Mr. Van Lieshout objected because the court recorders would note down everything. I asked it because we have already had very serious issues with what is written versus what was said in the previous case, the Memo case, the one I was fully acquitted for eventually. You see, in the first case, they twisted our words in such a way so that they can say, but you said that when you did not say that. This is how they work in the courts. And because when you are sitting in courts, you don't have to sign any documents there anymore. It is whatever they put on paper that is then going to count, because you don't get a chance to see what's put on paper, because they never, ever give you those documents right away. Mind you, we were questioned September 27, 28, 29. That's when we were questioned in 2021. You know when we get the documents of what we said in that questioning? November 12th, 6:15 in the afternoon. To go to trial, November 15th, 9 o'clock in the morning. That's justice. That's how they do it. Because you cannot change anything there. Because they say, that's what I heard. That's what it is. If you like it or not. Now, again, they never sent us any transcripts in time. We received the witness statements, I believe, from all the witnesses we heard in our case. In first instance, we got those, I believe, on November 8th. Yeah, November 8th, I think it was. And I'll be honest, most of it was quite accurate. There were a few things that we said, no, that this wasn't said so, but it did not really influence, basically, how it was said. But the testimony of Roberto Babadou Flanders, Leroy Lapé, Maria Boncampo, and Claudius Boncampo, me, did not come on the 8th of November. Lo and behold, those reached on November 12th, the Friday afternoon, not even 2 o'clock in the afternoon, no, 6:15 p.m., when everything is already closed. So you can't even say, I'm going to the courthouse because something is wrong. No, it's closed. They made it seem as if the defendants would just implicate themselves and others for things they didn't do. Because that's how the statements were. Everybody was implicating each other for doing this and doing that. But that's not true. If we had been permitted to record the hearings, this would not have ever happened. And we would have had the proof to force the corrections in the statements so you can see why they do certain things. Because that way they can guarantee the outcomes they want. Let me read some of the emails regarding this whole incident between my lawyer, Mr. Bloom, the defense lawyer, Ms. Bommel, and the judge, Stephen van Lieshout. All of these emails started when lawyer Bloom sent an email asking to cancel the hearing set for Monday, the 15th of November, seeing that we didn't receive various statements. I'm going to tell you from who the email is and the time. Stephen van Lieshout, caribjusticia.org, Friday, November 12th, 2021, 12:04 p.m. CC to Jairo, Petra Bost, and Danny Haziacher. Those were the two prosecutors. Subject, aanhoudings, verzoek, zaak Ruby. Dear Mr. Bloom, I translated it from Dutch to English so that we can all follow it. Dear Mr. Bloom, in response to your email of today, the following. The defense has all the testimony of witnesses in the case against your clients. In your email, you're talking about incriminating statements which you do not yet have. Insofar as you mean the substantive statements made by Lapé and Flanders at the hearing, it applies since the cases were heard at the same time but not joined. they were only made in their own case and not as witnesses in the case against your client. This is the judge speaking here. Heard as witnesses in the case against your client, they invoked their right not to testify, as can be seen from the official report sent to you last Monday, November 8th. Now, why do I read this piece? Because in the verdict, clearly states that LaPaix was heard as a witness in my case. That's a goddamn lie. The judge says it here. Heard as witnesses in the case against your clients, they invoked their right not to testify, as can be seen from the official report sent to you last Monday. But in the verdict, they testified and confirmed that they gave me money. All right? Let's continue, because it's far from finished. Nevertheless, and here it comes, the court is prepared to accommodate you, provided that also with the other defendants and their counsel, it can reach a substantive hearing for the week of the 20th to the 23rd of December 2021, preferably 2 days on the 21st and 22nd and or the 23rd. Earlier than that is not possible in the scheme of the courts. I hope that the public prosecutor will be available. I would like to hear from you and Ms. Lawyer Bummel with whether this is agreed, because I don't feel free to forward your email and this answer to Mrs. Bummel. I leave the initiative to contact her with you. If it's not possible to arrive at a jointly agreed hearing date within a reasonable period of time, the cases will be continued next Monday and Tuesday as agreed and announced. Sincerely, Stephen van Lieshout, Judge, Court of First Instance. At 2:12, again from Judge Stephen van Lieshout to Jairo Bloom and all the others, dear Mr. Bloom, at this time, the court does not intend to add the statements made at the hearing by LaPaix and Flanders in their own cases to your client's file. If for whatever reason this changes, you can of course claim extra preparation time. This being the case, I propose on Monday and Tuesday as previously agreed. The minutes of the remaining part of the previous hearings are currently being finalized. We expect to be able to distribute this by the end of the day. People, these are the statements of LaPaix, Flanders, my wife, and myself. We are now talking here 2:12 p.m. Friday afternoon. We still don't have the statements. And they said, since they ain't going to put them in my case file or my wife's case file to use against us, they would like to proceed. But if they do so, we're going to get more time. Well, we didn't get more time because we proceeded on Monday. But in the verdict of first instance, clearly what they said was at the center of my conviction. Those unchanged, doctored statements were at the center of my conviction. That's why they were heard by a judge of instruction in appeal, because that was the only place we would be able to confront the statements legally. At 3:06, Stephen van Lieshout, the judge, once again to my lawyer, dear Mr. Bloom, it follows from the scheme of the law that it is not possible to use statements made by a defendant in one case as evidence against a defendant in another case without joinder, which means hooking. Cases are then put together. The fears you have expressed are therefore unfounded. Because Jairo, my lawyer, said, if I start picking up those statements, use them against us, that's a problem. He said it cannot be because the cases were not joined. They were heard together, but not joined. To be clear, later today, as usual, you will receive one official report containing statements from all suspects in the Ruby case, but in each case, only the statement made by the suspect in question in his own case applies. That is clear from the words stated in the minutes, simultaneously but not joined. So we were heard together, simultaneously, but not as one case. The case will therefore continue on Monday and Tuesday as agreed. I would ask you to save further discussions for the sitting, as it is there where decisions will be taken. We will now turn to the official report. Sincerely, have a good weekend, the judge. At this point in time, this was 3:06 in the afternoon, Friday afternoon. We had no clue how the court statements would look. Well, again, we got them at 6:15. And it was a complete disaster. The statements were full of adjusted passages, added in statements from police hearings to do as if it was stated in the courts, and much more. Let me give you a passage of the defense lawyer of Mr. Flanders and Mr. Lapierre, Mrs. Bummel, the lawyer, which she started her pleadings with on Monday, November 15th, 2021, with this correction on the statements of her clients. These were the same statements that were used unchanged by the one that wrote the verdict in appeal. Point 2. Furthermore, during the hearing, Mr. Flanders never made any reference to the annual turnover of Roberto & Son. He could never have said this. There, Flanders was not at all concerned with the administration and turnover of the company. It is therefore unclear to the defense where this comes from. Both clients have indicated to your court that what they stated at the police officers is correct, and they stand by what they have stated to the police. To enlighten you, in the 7 hearings of Mr. Lapierre by the police, which he signed, he always said, I was greedy, and if I got paid, Babadoo paid, Roberto paid me. But he never did, nor did he ever see Babadoo pay me. Mr. Flanders, by the police, in 6 statements that he, or 7 that he gave, and never signed one statement because he said he don't trust them, never stated that I asked him for money, that he gave me money, that I pressured him to do anything. And the reason that last one was important is because they said in the defense that I had put psychological pressure on Lapierre and Babadoo. Anybody that knows Sint Maarten knows that that's a bunch of BS. But hey, it is what it is. This is how it works in the courts. Point number 3. The official report also, and the official report, this is now the suspect's statement that he said in court, also state that Mr. Flanders said various things about the amount of 188,000 guilders. During the hearing, Mr. Flanders did not say anything about it. That others also had to pay and that others were fed up was not said during the session by Mr. Flanders. Nor did Mr. Flanders indicate at the hearing that he was by Vromi in connection with the procurement of the contract for the landfill management contract. As it also is apparent from the statement of both Mr. Flanders and Mr. Lapierre, Mr. Flanders had nothing to do with the preparations of tender documents for the management contract of the landfill. With regard to the hiring of SIFs and Mr. Anthony Bonkamper, Mr. Flanders merely stated at the hearing that it was Mr. Lapierre who had been involved in this. The only thing he said at the hearing is that he knew, or at least was informed, that SIFs and or Maria had been hired because the company needed an administrator, and that Mr. Anthony Bonkamper was hired by Mr. Lapierre. More than that, he did not say at the hearing. In the documents, in their statements, it went as far as Lapierre stating he was put under pressure and all kind of things to hire my wife to do the administration, and that I forced him to hire, me and my wife forced him to hire our son. In the statements by the police, that is totally different, because Lapierre said he was never put under pressure, and he asked me If I know of an accountant, and I said, yes, my wife is an accountant, if you would love to give her a job, I would appreciate it. I said that. I don't have to hide about that. This island is small, so it means that nobody in my family can work with anybody that got work from government. I didn't give the work. I advised on the work. I didn't sign the contracts. I advised together with another civil servant. We advised. That advice was scrutinized by the SG, Mr. Lewis Brown. And he approved it and sent it through to finance and all the other places. But I am the one that fixed that. I make sure the governor signed it. I made sure the Council of Ministers approved it. This is how they decided to make things happen. But you see, for the courts of appeal to save face of what happened, they said we couldn't prove different with the statements as written by the court recorders and accepted them as such. But in my opinion, those written fraudulent court PVs, those court statements on the 4 suspects, that was sanctioned by a biased judge. Because the judge also signed off on them. Make no mistake. But you know, at the end of the day, the face-saving scenario, justice was not done. The arguments necessary to support the decision that they made last week, Thursday, are missing. Anybody with a legal background reads the verdict that was posted online can tell you this is not a verdict. Something is missing. Where's the evidence? There's no evidence placed in the verdict. None. The decision seems like an effort to correct errors that were made in the first instance, and in doing so, they made more errors. This experience is, of course, disappointing, but we now continue to fight for justice at the Supreme Court. This experience and repeated process with many procedural failures harms the trust and confidence that you have or want to put in the legal system in Sint Maarten. The trust is already very low in Sint Maarten for so many reasons. This is just one more. These type of floppy decisions make you realize that there are more important issues for the court, like protecting each other, than serving the objective it was created for, and that is to do proper justice. The court, even after receiving the testimony of the Finance Secretary General on the process in government, supporting that my actions were in accordance to the procedures within government, ignored this completely to support a conviction. Imagine that in an entire government process involving many persons on different levels, one man, me, following directives and procedures, is found guilty of a crime because I did it. Mind you, the government got their procedures in place. I follow them because that's what's told to me. And then yet I'm found guilty. No explanation why the law does not apply to me in such a case, and no punishment can be given. But a fast hop along just to come to a conviction with a statement that the financial controller's testimony was not relevant because she was not there at the time is ludicrous. Because the financial Secretary General was there for the past 15 years. He was there when it happened. He said that there was nothing wrong. It's not the way to do it, and they changed it in 2018, but that's the way it was, approved by all previous governments. They all knew that's the way it was being done. But I get picked out of the group, layers above and layers below. I am picked out, and I am taken asunder legally. Again, with a statement that the financial controller's testimony was not relevant because she wasn't here this time, while the statements of the Vromi SG, Mr. Lewis Brown, and the finance SG, Mr. Arno Pales, who were there, and the source documents that we brought in, I'm now talking about the sewage plant Stel Post, were ignored in this fast step. They just simply pushed all of that aside and just said, because the financial controller only started working in 2016, she don't know what happened in 2013. That's not true, because the documents were there. The documents spoke the truth. And she investigated what happened in 2013 and 14 using the documents at finance on the instruction of the SG of finance. And she gave a report of that. And yet, that's pushed aside because it ain't so. We need to catch Bancamper. We need to hold on to Bancamper. It is not what I would have wanted to go through all three levels once again to receive justice, but I did it once before, and I will do it now again. When the first cases ended and my legal costs had to be reimbursed, the payment came as a burden to the country, not those who did the investigation and made their errors. They just get a free pass. They buy Audis and go back to Holland. Once again, I find myself fighting all the way to the Supreme Court against the poor justice system we have in Sint Maarten. One thing is clear: an overhaul of the justice system is needed, in the hope that we get a system where bias is left outside the courts. Integrity and application of the law stands firm and sets aside all other agendas. Now more than ever, I will campaign and contest the upcoming elections because we have a lot of work to do. For some dumb reason, there are people out there telling others that I cannot run or take my seat if elected. Let me clear this up once and for all. I am running as the number 2 candidate on the Now Party. I will be elected and I will take up my seat in Parliament. Contrary to what the Daily Herald published, I was not given a 3-year ban on holding public office. I was given a 7-year ban working in the government apparatus. If you can't read, then don't write the story. Once again, another misleading story about me and the Now, trying to inform people that even if I win, I cannot hold office. Utter nonsense, once again. Let me close today with a few things. I've taken good note that the more posters have now been placed in the roundabouts. And it's clear that the police has no place, no authority to act by those responsible for proper justice. Clearly, the good lady can't do a damn thing until the amended budget 2023 that has now reached Parliament and is starting in a few minutes passes, or else there will be no support to pull off another Duran payout trick to the justice workers like was done in 2019, 2020. So if the budget passes, the police will get the instructions to clean up the roundabouts as the law states. I'm happy the police caught the 2 armed robbers who tried to rob a jewelry store in broad daylight in Old Street in Phillipsburg. Clearly, they are not afraid to commit the acts, so we will need plenty more police on the road during the holidays. Having 3 police officers working in a shift, like what happened yesterday when a lady called to ask for assistance down Back Street because people were throwing garbage all over the road. They couldn't come because 2 police officers were busy handling a call with a shooting, and the third one was guarding the police station and the prisoners upstairs. This is where we reach, people. This is where we are right now. A few nights ago, in Kimsha, across the parking lot there by where they got a Chinese got open lot, 2 boys jump off a scooter, hold a tourist, put a gun to his head, beat him with a gun, who was here recovering from a surgery he had just done, or he's a surgeon and had to do a surgery. whichever one it is, the message we are sending to the tourists and to people is not the message we should be sending. We need to understand that we got some serious changes to make. And clearly this government cannot make them or don't want to make them. Can be different. Again, just for clarity, I want to once again state the following. I am running this election. You see it here? The future is now. And after winning my seat, I'm taking my seat as stipulated by law. My verdict does not speak of me losing my active or passive voting right, which means I can vote and I can be elected. The nonsense writing of the Daily Herald of December 1st on page 9 that I was sentenced to a 3-year ban of holding public office is a lie. And I hope they correct it. But I know they normally don't do those things because they don't care. They have the verdict, I know that. So why publish untruths? The law doesn't allow a person to be punished twice for the same crime he's accused of and or convicted for. I was punished in this present parliamentary term when I was suspended. They cannot suspend me in a new parliamentary term for the same thing. Those that don't know, please go and check the law. Go and ask those that know, instead of celebrating in bars and in clubs that I don't know. I'm so far from done, or you don't even know. But nevertheless, today I didn't come to worry them. The bashing, I leave for them. The truths and exposing the things that are wrong, I will be doing. Wednesday now, I'll be on Grace. I'll be going through the manifesto of the Now. I'll be focusing a little bit on the tax reform, the way the Now sees it, and how we want to spread the base of taxation to prevent the local people in Sint Maarten, the residents, paying the full brunt, while many others walk away scot-free and make lots of money here in all sorts of constructions. I'll be talking about that on Wednesday. I want you all to have a great week ahead. Please share my podcast and also like and subscribe to my YouTube page. I am still busy with the investigation and the garbage collection, and I will be getting that report to you all in due time. Don't worry about that. Bunks is out. Take care.